G'day everyone, and welcome to Laws 11061 Contracts A. This week we're looking at topic 7, which is all about skills. And yet again, surprisingly enough, my name is Anthony Marinac. Learning objectives for this week. Well, this week's a little bit different because last week we concluded our study of the formation of contract, and this week ordinarily we would be going straight on to look at the construction of contracts, but this is the first semester that I've taught this course, and when I had a look at the previous arrangement for the course, I thought, you know what, we've got week 12 at the end of the term, and it's down as a revision week, but really what it is a study in a mad panic week to try and get ready for the exam. And as a result, I felt like what the students were getting was really 11 weeks of instruction and then a week where we pretend to give you some instruction, but basically you run around studying. What I'd rather do is give you 12 actual weeks of instruction, and what I thought we could do rather than having a review week is take that week in the middle of the term to talk about some skills. And the skill that we're going to talk about is answering legal problem questions. Now, why have I chosen that? Well, legal problem questions are something that's really quite distinctive to the study of law. You may have studied successfully in other disciplines, and I studied another discipline before I came to the law, and you find that when you come to study law, problem questions make up a really substantial portion of your assessment. And there's something that you really have to get your head around if you wish to do well as a law student. Now, one of the other subjects that I teach commonly here at CQ Uni is evidence law, which is a third-year subject, and it's normally taken by students who are not too far away from completing their degree. Quite often students who are in the final year of their degree. You'd think that by the time students got to the final year of their degree, they would be completely across how to write good answers to problem questions. But I've been consistently surprised by how difficult a lot of students found it to write what I considered to be a great answer to a problem question. What that means is that I can do you all a great favour by taking some time right now at the start of your degree to help you to understand the best possible way to write great answers to problem questions. What I'm going to do is walk through step by step my guaranteed to work method for answering problem questions well. Now, those of you who have the notes will see that what I've done in the notes is worked on an actual problem question and gone through it step by step to produce what I consider to be an HD level paper at the end of the process. I've also put a second problem question down there. Now, this is voluntary. I repeat, it is voluntary. You can ignore it if you like, but you're nuts if you do. Yes, I understand that you've all got other assignments due and that this is a particularly busy time of the year for you all. But if you can possibly find the time to have a crack at that problem question, I will give you as much feedback as I possibly can, and hopefully it will help to cement some of these skills that will actually save you time in the long run, because you'll be able to successfully study for and successfully complete problem questions down the track. Honest truth, they're not done real well, which means that if you can be one of the students who does do them really well, you're going to get a huge advantage compared to others. So, what's a problem question? What is it all about? Well, most university examinations and assignments ask you to demonstrate knowledge. So they'll pose a question and they'll say, okay, discuss this question. And you write an essay in response. The law's not like that. The law is usually adversarial, and a lawyer's role is usually about providing advice. So what a problem question does is it puts you in the middle of a legal dispute. It tells you whose side you're on, and you don't have any choice about whose side you're on usually, and it asks you to provide advice to one of the parties. Now, this is much more complicated than you might at first think. The way that you demonstrate knowledge to the examiner is by showing not only that you understand the legal principles that are involved in answering the question, but also that you can formulate those legal principles into a sensible legal analysis, and that on the basis of that sensible legal analysis, you can provide advice to the client. Now, I reckon this is easy, but I reckon this is easy because I've done dozens of them and I've marked hundreds of them. But there is a system. This is the system that works for me, and I think it's pretty darn good. You might want to modify it for yourself along the way, and that's fine, but this will give you somewhere to start. If you follow this system and do no more, then you almost can't avoid getting a pretty decent mark for a problem question. First step, read the question. Now, that sounds like it's pretty obvious. You read the question. And most of you would say, well, I do read the question. But I don't just mean read it. I mean really read it. 3 or 4 times through if necessary. First time, just read it like a novel. Second time, now that you've got a basic understanding of what the facts are and where they're going, the second time through, read it again and just ask yourself, who are the parties? I'm sure that most of you were forced, as I was forced, to study a bit of Shakespeare coming through high school. If you didn't do Shakespeare, you would have done some other sort of play. And customarily, when a play is published, at the very start of the play they say, here is the cast of characters. Well, do the same thing for your problem question. Who are the cast of characters? What are their names? What are their legal roles? And what do they do in real life within the context of the question? So you might say, there's Bob, he's a builder, and he's the plaintiff. That way, when you're reading the question, you don't start to get lost in terms of who is what. You quite often find that examiners will be very amusing and they'll give characters in problem questions funny names like Bob the Builder that I just used a moment ago. And this can actually be a real distraction. And you can get to the end of it and think, no, hang on, who's the plaintiff again? Who's on which side? So make a list of the parties. That's the second reading through. The third reading through, you're saying, what actions can have possible legal consequences? Now, at this point, it doesn't matter whether you get them right or wrong. If you think an action might potentially, possibly, maybe even have legal consequences, bung it in there, because you can certainly eliminate them later on. The next reading through, so this will be the fourth reading through, ask yourself, what are the different questions? Because what you'll see by this time, you're starting to get really thoroughly familiar with the material. You'll see that there's a couple of different issues going on. And so you can separate those issues out, because quite often the examiner won't have separated those issues out. They'll quite deliberately have muddled them all together so that you have to separate them out. And then establish a timeline for each of those separate questions, each of those separate issues, so that you're pulling out from the narrative just the bits of the story that are important to each question. Okay, so first the plaintiff did this, then the defendant made an offer, then the plaintiff accepted the offer, then the defendant tried to withdraw the offer, then the plaintiff tried to insist that the offer had now become a contract. Right, so you can see, you can pull the various bits out of each question so that you're not constantly getting confused by information that is written into the problem question, but that's not actually relevant to the question that you're trying to answer at that specific point in time. Now, all of that is just reading the question. You haven't really even started answering it yet. What you have done is you've read the question intelligently. You've said, okay, I've not just read this as a story, but I've started reading it analytically. I've started looking at the question as though it was nothing more than a bunch of data which I need in order to successfully provide advice to a client. Once you've done that, once you are seriously familiar with the question, then you can move on. One way to tell that you're ready to move on is to put down your notes, put down your iPad, put down the question, and go to someone who doesn't study law at all, your mum, your partner, whoever it might be, and tell them the story. Tell them about the question. If you can tell them pretty comprehensively what the question is all about and what it all means, without relying on any notes, then you're probably ready to move on to the second step. The second step is to identify the issues. Now there's two things to think about here. We've already started looking at the issues while we were reading the question, but now we're going to get a little bit more selective. The first thing we have to work out is an issue of fact from an issue of law. Now, what on earth is the difference? You would be surprised how many advanced students of law I've come across who really struggle to explain what is the difference between an issue of fact and an issue of law. So let's take a little scenario. Let's imagine that we have a car which has been involved in a single vehicle accident. Okay, it's let's say it's hit the light pole supporting some traffic lights. It's done damage to the car. The police have been called. And there's a question that arises about whether the car was speeding at the time that the accident happened. Now, in order to work out whether the car was speeding, there are two things we need to know. We need to know one piece of law and one piece of fact. The piece of law that we need to know is what was the speed limit. You see, if the car was doing 75 but it was an 80 zone, then the car wasn't speeding. If the car was doing 75 and it was a 40 zone, the driver's in a lot of trouble. Okay, so the first thing we need to know is what is the law. The law says the speed limit is 60 kilometers an hour. The second thing we need to know is the fact, and the fact is how fast was the car driving. So we need to know one piece of law and one piece of fact. And you can see that they're different. If we have a dispute about whether or not the driver was driving inappropriately, we could turn that into a dispute of fact or a dispute of law. The dispute of fact would be two different sides, each saying that the car was travelling at a different speed. So let's say the prosecution and the defence both agree that the car was travelling at 75, but the prosecution's saying he was travelling at 75 in a 60 zone. And the defence is saying, no, you've got it wrong. He was actually travelling at 75 in an 80 zone, because it's an 80 zone there. Well, that would be a question of law, wouldn't it? So what we have to do is go back and look at how the law applies to that particular place and say, what is the law? Do we all understand the same thing when we're talking about the law? The question of fact, on the other hand, asks about the actual circumstances of the time. So let's say both sides were agreed that the speed limit was 60, and the prosecutors said that the car was travelling at 75, and the driver says that he was travelling at 55. There we have a dispute of fact. Everyone agrees what the law is. Everyone agrees that the speed limit was 60. What they disagree with is the speed the car was actually travelling. So now that you've read the problem question properly, and you've identified the issues, ask yourself in relation to each, is this an issue of law or is it an issue of fact? most of the time, when it comes to a problem question in law school, you're going to be looking for the issues of law. If there are issues of fact there, by all means identify them, but usually you're not going to be able to resolve them, because the way in law that we resolve issues of fact is through evidence law. And until you get to my third year subject, you won't really have to worry about evidence law. The second thing to think about in this second step is non-issues. Non-issues are what we refer to as red herrings. These are things that are put in there in order to try and distract you, in order to try and make it harder for the students to identify the actual issues. Now, we do that as examiners because that's one way that we can learn whether or not you genuinely understand what the issues are. Because a student who genuinely understands what the issues are will be able to pick out the issues from the non-issues. So there might be something in there that draws your attention immediately. And you think, this is an issue. Have a really close look and make sure that not only is it an issue from the perspective of the players in the situation, but also that it is an issue for the purpose of the legal dispute which is currently underway. There are plenty of things that might look untoward but that are not issues. Once you've identified the issues, you can then proceed to the third step. The third step is to identify the relevant law. Now, what you can see immediately is that we're probably talking about disputes of law rather than disputes of fact. So in order to resolve a dispute of law, we have to start by finding out what the law actually says. It's not good enough, though, just to say what the law says. You need to also identify the authorities. So you need to be able to say which cases or which statutes actually provide the statement of law that is relevant to this particular issue. There are a few things that students do that puts them in dreadful trouble with problem questions at this point. One thing that students do is they cite from sources like their textbook or my lecture notes or Wikipedia. Let me tell you right now, none of those things are authorities. Maybe the day will eventually come when Anthony Marinac's word is law in Australia, but I can't really see it happening anytime soon. The revolution is many years away, my friends. And until the revolution comes, the only authorities that you can legitimately quote or legitimately cite in a problem question at law school are cases and legislation. The only time this changes slightly is if you're dealing with a question of international law, and you won't be. Okay, unless you're actually studying international law, you won't be. So for our purposes, the only acceptable authorities are cases and legislation. Please, 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 please do not try to impress me or any other lecturer by citing our lecture notes as the basis for your understanding of the law. Because the reality is that what that tells us is that you haven't bothered to go and find the cases for yourself. It's worthwhile doing the research properly, and it's absolutely imperative that you rely on actual authorities. Now, there's plenty of occasions in the law where the law is not settled. One thing that you're going to find when we get to week 12 of this course, we're going to discuss a concept called privity. Now, privity in Queensland is very well settled because we have a beautiful piece of statute that resolves all of the problems. But privity in the rest of the common law states of Australia is not settled at all. And we have a High Court case where the High Court, which is only 7 people to begin with, split in 4 different directions about what was actually meant by the doctrine of privity and how it worked. In these situations where the law is not clear, where the law could easily be interpreted one way or another, say so. Okay? Sure, you're going to have to come to a conclusion. You're going to say, this is how I think the law would be applied in this case. But there's absolutely nothing wrong with saying, however, the law is quite unsettled in this area because the High Court in such and such a case split off in 3 different directions, and therefore it's not possible to be entirely confident about the interpretation that this section would be given. Perfectly legitimate. In fact, you'll probably get bonus points for showing that you really did understand understand what the state of the law was at that point. So we've identified the relevant law. We've cited the appropriate authorities. We've understood that Anthony Marinac is not the appropriate authority. The next step is to apply the facts to the law. So at this point, we're now going back to the story that we were given. We're going back to the initial problem question. And we're looking at the timelines that we established on our 3rd or 4th reading of the question. We've worked out the issues. We've worked out the laws that apply to each of those issues. We've provided authorities for each of those. Now, it's time to go back to the facts and list the facts that relate to each of those points of law. Do it systematically. Don't get carried away with the most important issue and give all of your focus to that. One issue at a time. You look at each point of law and you say, right, in order to assess this point of law, what facts do I need to know? So, if we were looking at that speeding question earlier, what facts do we need to know in order to establish whether a car was speeding? Well, we probably need to establish 2 facts. First, we need to establish what the actual speed of the car was. And second, we have to establish whether or not there was a sufficient reason for the car to be travelling faster than the speed limit if that's what it was actually doing. Okay, there are circumstances in which it is permissible to exceed the speed limit. So there's the facts that we would need in order to apply those facts to the law that we've just identified. Now the final dot point that I've indicated there in this 4th step is that you need to be prepared to apply bad law, and you need to be prepared to reach unjust outcomes. Now this is going to be really challenging for a lot of people, and I would say it's probably one of the most challenging things that law students come up against when they start the study of law. And for some reason it seems to particularly affect mature age students who have a bit more experience of the world and who usually come to law study with a sense of justice and an understanding of how the world should be. Very often you will look at a problem question and you will feel a great deal of sympathy for one party or another. You will have in mind the idea that one party or another should win the dispute. If you're lucky, it'll turn out that way. If you're not, if you apply the law to the facts of that situation and you find that the bad guy wins, that's the decision you have to make. That's the conclusion you have to draw. You don't have to like it, you just have to do it. One of the things that we as examiners will do from time to time is quite deliberately put a question into either an examination or an assignment where a thoroughly unlikable character ends up winning the day and getting rich. We do that simply to make sure that students are relying on their legal analysis, not on their sense of justice, in order to come up with the right answer. If you're going to be helpful to your clients in the future, you need to be able to provide them with balanced legal advice, even if your advice to them is that they are the ones who are in the wrong and that they ought to do something to try and resolve the matter quickly. You're going to be much more useful to them if you're prepared to say that than you will be if you pretend like they're going to win the whole thing and lead them headlong into disaster. Fifth step, consider the alternatives. See, sometimes we're all wrong. Sometimes I'm wrong, sometimes you're wrong. If you're not, if you're completely infallible, then I would encourage you to advance this recording by about 3 minutes and go straight on to the next slide. But if, like the rest of us, you make mistakes from time to time, there's a way to cover your bases. Now, you don't want to do this on everything, but from time to time you will see issues where you say, right, this is my legal analysis of the answer, but I'm not entirely confident of it. And if I'm wrong, if I've misunderstood this aspect of the law, or if the other side is able to bring these sorts of facts, then the case might turn out very differently. If you've done that analysis and you can show what the other side of the argument is and what the strengths of the other side of the argument is, and you can fit that in within the word limit, by all means do so. So you say, this is my argument, and this is the alternative argument which would prevail if I was wrong. By doing that, you accomplish two things. First, you show me as your examiner that you seriously understand the application of the law to that question. Someone who can argue both sides of the law on a particular question is genuinely demonstrating that they have a high level of knowledge. Second is that if you actually did get it wrong, you've also given the right answer to the examiner. You're never going to be able to recover the fact that you've gone with the wrong option, but what you can get away with is saying, look, even though I went for the wrong option, I did have a very strong understanding of the law in this area. Now, I can't speak for the entire community of legal academics, but for me personally, I'm going to give you just about as good a mark as if you had actually gotten it right. Because what you're trying to do with these assignments is demonstrate your knowledge to me as the examiner. And you've done that, so I'm going to give you a good mark. The sixth step, conclude. Now have a look at that dot point. It says answer the question. Please, please, please answer the question. I can't even begin to tell you all how many times I have marked law papers from this university and other universities where the students have given an absolute brain dump of everything they know or everything that's in the notes that they've taken into the exam room about a particular topic. So they'll look at a contract topic and they'll say, oh, I've identified the issue here. The issue is all about capacity. And there's a second issue here about intention to create legal relations. And so what do? They give me 2,000 words on the issues of capacity and intention to create legal relations. Well, from one perspective, that's great. That's fine. I have no problem with that. Except it doesn't answer the question. And it doesn't show me that the student has been able to select the appropriate bits of law out of those areas, out of those topics, and stitch them together in a piece of legal reasoning. So they've done the research, but they haven't done the analysis. Now, a student like that might well pass because they have probably demonstrated enough knowledge to get them over the line, but they are not going to get a good mark, and they're certainly not going to get a mark that's good enough to reward them for the amount of effort that they've probably done to do all of the research. The simple reality is, I cannot give you a good mark if you don't answer the question. Now, there are two things to be aware of in terms of answering the question. First, actually look at what the question is asking you. If the question asks you to advise Mark, and you give me a piece of written advice for Sally, you're going to get a poor mark. You're going to get a poor grade. Because you weren't told to advise Sally, you were told to advise Mark. You might get an entire fact scenario given to you, and then the question might be, which of the two parties is more likely to win? Or the question might be, is there a contract? And then in brackets after that it might say, you may ignore any aspects of this question not related to contract formation. Well, anyone who doesn't ignore those aspects, anyone who gives me 1,000 words on contract formation and then 1,000 words on breach of contract, well, that person's going to get a poor mark because they haven't actually read and thought about exactly what they're being asked to do by the question. The second thing with concluding is that you need to actually come up with a conclusion. You can't sit on the fence at the end. You can't say, well, the client should do this, this and this unless they would prefer to do that. You need to actually come up with a piece of advice that answers the question. You are better off coming up with a conclusion which turns out to be wrong than you are not coming up with a conclusion at all. Now finally, once you've done all of that, once you've done all of those 6 steps, you can then draft. So you shouldn't actually be starting to write the answer to the question until we get as far as this 7th step. But by the time you get to this 7th step, you have done all of the research. You know the points of law, you know what your analysis is going to be, you know what your advice is going to be. You've picked out the bits of the question that you need to actually respond to and the bits that are irrelevant. You've got a structure for your answer that is almost self-evident from the notes that you've made along the way whilst reading. You almost can't help writing a great answer to the question because the preparation that you've done puts you in a fantastic position to do that. I want to talk about just a couple of things to do with drafting. You will have all done, or perhaps you're doing at the moment, the first year course on statutory interpretation, which talks about some of these issues. Towards the end of your degree, you will do my subject on advanced statutory interpretation and legal drafting. And we talk a great deal in that subject about the process of drafting, about the process of writing like a lawyer, writing like someone who is an expert in words. And you'll hear me say over and over again that the law is made of words. And so those of us who wish to make our living by working with the law must be experts in the use of language. That means you need to write tight. It means that you can't write in an overly legal style just for the heck of it. Don't use jargon terms that you don't understand. Don't try and write impressively by using large, unnecessarily unwieldy terms. Keep it simple, keep it tight. Make sure that every word that you write is there for a reason. And don't just write one draft. Write a draft, put it in the deep freeze for an hour or 24 hours if you can manage it. Walk away from it. Don't read it. Don't think about it. Come back to it fresh and proofread it again. There's nothing so terrible as an assignment from a student who has obviously done the work, who's obviously done the research, done the analysis, and then they come to write the answer to their question and it's just terrible because they just haven't bothered to go and proofread it. Why would you cheat yourself? Take the extra hour or so that is necessary to properly proofread your assignment. If you follow all of these steps, there's almost no way you can write a bad assignment. You'd have to thoroughly misunderstand the facts of the question and thoroughly misunderstand the meanings of the law in order to write a bad answer to a problem question if you follow this process. And if you're in the position where you don't understand the facts or you don't understand the law, well then no system of writing assignment answers is going to help you. The real key is to be systematic. Take it step by step. Don't get drawn out of sequence. Don't get fooled into getting overexcited and starting to write bits of assignment from scratch. Follow the process. Read the question. Read it again, and read it again. Identify the issues and the non-issues. Apply the relevant law and make sure that you've supported that relevant law with authorities, which means cases and legislation. Apply the facts of the actual problem question to the law. Think about what happens if you're wrong. Think about whether or not you should be presenting any aspects of the alternative argument in your problem question, in the answer to your problem question. Come to a conclusion. That means an actual conclusion where you say what you reckon. Then you can draft a tightly written, logically ordered answer. At that point, you can submit it and the assignment becomes my problem. Now listen, I really hope that this week, coming as it does in the middle of the semester, is really very useful to you. And I would love to receive your feedback on whether or not this week's worth of skills puts you in a better position to do well, not just in this subject, but in all of the subjects which you study at law school. Learning to write great answers to problem questions is difficult. There's no way around it. It takes practice, and it's one of the skills that you do have to learn on the run as a law student. If you can master it, if you can put in the effort, then you will shine. You will take the learning that you do from a week-to-week, on a week-to-week basis as you move through the course, and you will deploy that learning in a way that gets you the best possible marks as a result of the effort that you've put in. Now that you've heard this lecture and hopefully read the notes, I'd really love it if you took a crack at the practice problem question which is in the notes. I'm really looking forward to reading the efforts that you put in, and I will do my very best to provide you with useful feedback in response. Next week, we start our study of the construction and interpretation of contracts, and goodness me, but we're only 5 weeks away from the end. Have a great week.